Hello, everyone, and welcome back to yet another session on polity and constitution. I hope I'm audible as well as visible. Great. Audible and visible. Okay. Audio error. You'd need to refresh it. Savi, what is pets? Good evening, everyone. Let's wait for those to join, and then we'll begin our discussion for the day. Yes, Yashika, you can. No, don't say it's unconstitutional. Use the word ultra vires. It's beyond the scope of constitution. That would be a better way to put this idea of collegium. Calling something unconstitutional also sounds like it's something illegal. So let's not be that harsh also. So let's do a quick recap in the meantime. Others can keep on joining. So in the previous class, that is yesterday, we had taken up for discussion the second ARC recommendations pertaining to municipalities. And when it comes to the importance of local self-governance, we saw the significance of local self-governance. Why is it important? And we finished our discussion with the 15 Finance Commission recommendations, which have been accepted by the government. And hopefully in the next 5 years, we'll see the money being devolved to panchayats and municipalities, and a lot of it can be used by them to spend on their own aspirations and expectations. Then we moved on to studying judiciary. As far as judiciary is concerned, we looked into the Supreme Court, number of judges, how to increase the judges of Supreme Court, how to increase judges of the High Courts, all these things. Then we saw the appointment. Larger chunk of the second half yesterday was spent on making you understand the collegium system. Collegium basically is a group of judges who make recommendations to the president, which is largely binding, though there is no time frame within which the government has to approve the recommendation, but the government cannot select their own names. That's there. And we saw the critique. We saw the 99th Amendment Act, that is the NJAC, a very innovative concept. Countries like UK have borrowed this from largely India only, though their Judicial Appointment Commission has slightly different members. Nevertheless, and then we also saw the removal of the judges. That was the last point, removal of our judges of the Supreme Court and the High Court, because the removal of the judges of Supreme Court and High Courts are done in the exact same fashion, no difference at all. Sneha, sir, in the Ambedkar ji, there is written Chief Justice is the man of all failings and sentiments. It's failings. Failing means failure. Shortcomings. It's not feelings, it's failings only. Failings is an English word. It refers to shortcomings in an individual. So he may have some shortcomings, errors in understanding. He is also sentimental. That's it. SIAN. So yeah, it will be correct only. See, impeachment as a word, it's an English word, which means the procedure to remove somebody through the parliament. This is a British concept. In your history class, you must have studied about the impeachment of Warren Hastings, initiated by Edmund Burke in the UK Parliament. So, impeachment is basically a procedure through which the Parliament, the elected people, remove any high functionary. But in our constitution, the word impeachment is used only with respect to president. But in a question, that's okay. I mean, it's justified. Yes, Ganesh, that's a very good example actually. Where is sir? I am here. Obama's photo coming. What was, I missed out somebody's comment. Anyway. Okay. Now, let's begin our discussion for the day. The day we know starts with 5 questions. Starting with the very first question, 45 seconds of time. You know the deal. First question right in front of you. Please mark the answer. Saksham, this question can only be addressed once we study basic structure doctrine, not right now. So ignore this question for now. Oh, a lot of you marked C as the answer. They cannot be arrested during the session of parliament for both civil and criminal. Only civil, not criminal cases. Right? It is only for the president and the governors. But for the members, the parliamentary privileges, it is only the civil cases. The presiding officer of the House has the final authority in deciding matters. Of course, this is correct. So, 1 is wrong, 2 is right. B2 only is the right answer. Moving on, question number 2. Okay, got trapped again. How? The number of offices of chairpersons reserved for SCs and STs in the panchayats at each level should be in the same proportion to the population of the state. This is correct. Not less than 1/3 of the total number of seats amongst chairpersons in municipalities shall be reserved for women. This is actually wrong. Chairpersons, state legislature to decide. Members, it is 33%. For municipalities, it is in panchayat that 1/3 at least is reserved for women in members as well as amongst chairpersons. So 1 is right, 2 is wrong. Refer to the municipality slide, will get the answer. A, 1 only. Third question. Okay. So here, when a removal motion, sorry, the committee that investigates into the charges against the judge, that is a inquiry committee. It comprises of members of parliament, or it comprises of the chief justice or the Supreme Court judge, chief justice of High Court, and some eminent jurist. Right? So this is the inquiry committee, not the members of parliament. The inquiry committee for investigation for the removal does not comprise of MPs and all, it comprises of the judges. So 3 is wrong. Remove 3, you have the answer. And first 2 statements are actually correct. Fourth question. Anand Padmanabhan, it's a special majority. Okay, this was on the easier side. Gram Sabha. Gram Sabha is a village assembly consisting of all the registered voters, so above 18 voters in the area of the panchayat. C is the right answer. It is not assembly of all the people. Even kids will come under all the people, right? It's not an elected body. All the people of the area whose names are there in the voter list, they are a part of Gram Sabha. Pretty decent and easy question. Last question for the day. Okay, this was an easy question. Why a lot of you have marked it incorrect? In the case of ordinary bills, Rajya Sabha is equal powers, but LCs are subordinate to the assembly. Why? Legislative assembly is the one which decides on every matter. Legislative councils, remember, they are known as dilatory chamber. Correct. In case of money bills, yes, Rajya Sabha and the councils are subordinate to the Lok Sabha and the assembly. Money bills, so only the lower house has the power. So 2 is correct. C, both 1 and 2. That's it. We are done for the day. I mean, questions. We'll discuss the topic now. So, how was the performance? You can see the leaderboard. Amardeep, Natarajan, Abhijit, Priya, and Pallavi. Then Viswa, Shobhit, Aarti, Gayu, Janvi, Cherab, Kanishk, Roshan, Nitesh, Sulekha, Chahat, Bhakti, Shalu, Bhavna, Nikhil, Kamalpal, so on and so forth. Okay. So, moving on now. It's okay. Some days are good, some days are bad. Revision should continue. Now, we'll come back to our discussion, judiciary. salary and oath. So I think we have already seen this topic. The salaries of our Supreme Court and High Court judges is mentioned where? Mentioned in Schedule 2 of the Indian Constitution, right? This is also given as an information under Article 125. And oath, the oath of the judges of Supreme Court and the High Courts is mentioned in Schedule 3 of the Indian Constitution, Article 124, Clause 6 is the oath. Okay. Both Supreme Court and High Courts. And same here, both Supreme Court and High Courts. Okay. Now, one more very important point. There is also a law in the country. I mean, it may not be needed, but still, for salary, there is a law called Supreme Court Salaries and Conditions of Service Act. Salaries and Conditions of Service Act 1958. Okay. So this is there. Now, same standard problem here, or rather advantage here. Your salaries can't be reduced. Salaries, etc. can't be diminished. During office. And also salaries are what kind of expenditure? Charged expenditure. Okay, that's there. One more thing. I'll just mention this point here only for you to understand. Salaries, allowances, pension of Supreme Court judges. It comes from CFI. Are you clear? Also, pension of High Court judges comes from CFI. Clear? But salaries and allowances of High Court judges, this comes from CFS. Please focus on this point. The pension that the High Court judges obtain comes from the CFI. But the salaries they get, the respective states will provide that salary. Okay. And of course, a very important point. Every person who has held office as a judge in the Supreme Court, right, will not be allowed to plead or act in any court in the entire territory of India. So once you have been a Supreme Court judge, you cannot become an advocate. You cannot practice law anywhere in the country after retirement. Okay. Once you demit office from the Supreme Court judge's post, after retirement, you are not allowed to practice in any court of law in the country. Are we clear on this? I hope you know all these terms: CFI, CFS, lawyer, advocate. Hundreds of times we have discussed this now. Lawyer is somebody with a degree in law. When somebody is allowed to practice in court as a lawyer, he becomes an advocate. So all these things are there. Refer to your Attorney General classes, you'll get this information. This is actually Article 124, Clause 7. And I would request you to remember this article. with the clause, very important, because this actually ensures independence and fairness of a judge. It also ensures, or rather curtails, the interest of a lawyer. So if I am a lawyer and I have to become a Supreme Court judge, the option comes to me that, do you want to be a Supreme Court judge, very famous lawyer? I'll say, see, if I'm a lawyer, I can keep on practicing law till I'm 85, 90, 92, till I'm alive. But if I become a Supreme Court judge and then I retire, I can't practice law. So that's there. That is why a lot of lawyers are not very eager to become a Supreme Court judge, because as I said, lawyers are paid very high, they are paid very high fees to fight cases. So that would be a very, very huge cost on them. So they feel there's no point, right? So that's there with respect to Article 124, Clause 7. What about High Court? We'll come to this information when we study the chapter High Courts. Okay. Now, apart from this, there is a concept of ad hoc judge. What is ad hoc? Temporary. We know the word ad hoc. Ad hoc means temporary. So ad hoc judges, this is Article 127. Don't worry, I am just writing the articles. I will tell you towards the end. I think now we know how we study. Towards the end of our judiciary chapter, I'll tell you which articles are important. So don't go crazy about these articles. I am just writing them if in case somebody wants to remember it. Now, ad hoc judges. If quorum in Supreme Court is not met. Now, here quorum is not defined. Please don't use the same definition of quorum which is there in Article 100, 1/10. That quorum is meant for Parliament. If quorum is not met, what is quorum? Minimum number of people required for the court to function. If at any point of time there are very few judges, most judges on holiday, leave, some have retired, some are ill, for whatever reasons, the CJI can order High Court judges to attend the Supreme Court. Then the Chief Justice of India can call upon some High Court judges that, guys, come on, come here, sit in Supreme Court, give judgments, because we are running short of staff. Okay. Now, for this, prior permission of President is required. Number 2, you have to also consult with the Chief Justice of that High Court. Just consult, opinion not binding. And whichever judge you are inviting, the High Court judge, that judge should be qualified to be a Supreme Court judge, meaning he should have been a judge in the High Court for how many years? At least 5 years. These are the conditions that are there. And one more thing, if I'm a Chief Justice of India and I call, come on, you High Court judge, come here, sit in Supreme Court. And the High Court judge says, no, sir, I can't come to Delhi. Too much of pollution is there. I can't leave my hometown. I'm very happy. I'm feeling shy. Sorry, you have to come. Okay. High Court judge has to attend. Can't refuse. Clear on this? So this is there. Then we have a concept of retired judges. Retired judges, Article 128. Again, at any point of time, if I, the Chief Justice, feel that there are too many cases piled up in the Supreme Court and pending cases are very high in number, and I need to solve all these cases, but most of my colleagues are on leave, somebody is ill, somebody is getting their daughter or son married, somebody is on some other kind of leave, whatever. So I can also order retired Supreme Court judges, retired High Court judges to come and attend the Supreme Court, Condition, prior permission of President is required. And same, retired High Court judge should be qualified to be appointed as a Supreme Court judge. That's it. But here, since the judge is retired, retired judge may refuse to attend. So if I'm a retired judge, CJI calls me, come on, come and help me out. I'll say, sorry, I don't want to come and help you out. I'm enjoying my retired life. Don't disturb me. So this is a basic difference between a retired judge and an ad hoc judge. Are we clear? So this is there with respect to the concept of ad hoc and retired judges. Okay. Now, a very, very important point, court of records. This is Article 129. Article 129 for Supreme Court. Article 215 for High Courts. So what is a court of records? Firstly, the meaning of court of records. Court of records are the most superior courts in any country. So in every country, you will have some courts. The task of these courts is to interpret the constitution of the land, right? Those courts are the most senior courts, the superior courts. And court of record does not mean that there is a record room where the records are kept. No, no, no. Court of records means whatever judgment the court gives, that judgment becomes a fact. Judgments are used as a precedent by the lower courts. If the Supreme Court or a High Court gives a judgment, lower courts now use that judgment as a precedent. So when I, as a lower court, will give a judgment on a similar matter, I will use the same judgment given by the High Court. Also, the verdicts that are given, they are of evidentiary value from the word evidence. They are like evidence. Whatever verdict or judgment the Supreme Court or High Court gives, it becomes a fact now. If Supreme Court says today that the sun rises from the west, it becomes a fact. It won't say it, of course. So that's the logic here. Whatever judgment the court of records give, those judgments have evidentiary value. From the word evidence, they become evidence, they become fact. What is evidence? Fact. So this is what is called court of records. In India, both Supreme Court and High Courts become court of records. Are we clear on this? Now, coming to the special features of court of records. So in any country where they have their topmost court of records, those courts have two special features. In India also, the court of records have two special features. Feature number one, power to review its own decisions. So any court of record has a power to review its own decisions. That is why when a judgment is given by the Supreme Court or High Court, you can again file a case there and ask them, sir, please recheck, sir, once, sir, please. That can be done. But you can't do the same thing in a lower court. In a lower court, if a judgment comes, you can only appeal against it in a higher court. You can't go to judge again saying, sir, please, come on, recheck. But in the High Court, Supreme Court, it can be done. This is said in one case called Shiv Dev Singh case, 1963. Second thing, court of records have the power to punish for contempt. What is contempt? We saw this word in the parliamentary privilege also. Contempt means making any derogatory remark against the court, not following court's order. That's called contempt. So if today you make any derogatory remark against the court, court of records have the power to punish you for contempt. Are we clear? This is called these are the two special features of court of records, which are there in every country. In every country, if you have the topmost court, they have this court of record as a concept. Clear? Okay. So we have in our country Supreme Court and all the high courts as court of records. Now, what is contempt of court and all? We'll discuss that later on. when we study Article 19, because contempt of court is a limitation on our freedom of speech and expression. We cannot criticize the judiciary uselessly, passing comments. I cannot sit here and say judges are corrupt. If I don't have proof, I cannot make such statements. So that is called court of records. Clear? Okay. Now, Article 130. I'll repeat this statement again. Don't go crazy about articles. We know very well what is the format of our lectures. Towards the end of every module, we do mention important articles. You need to know those articles only. I mention the articles because if there's anybody who wants to read the article on their own, they can find that out in the Constitution. Now, Supreme Court shall sit in Delhi. We know very well that the Supreme Court is in Delhi, and but Supreme Court can also sit in other places. If today the Chief Justice says, come on guys, it's too hot in Delhi, let's go to Goa and chill. Give judgments there. So of course, they can sit in Goa also. Chief Justice of India can decide this with the President's approval. Okay, so with President's approval, the Chief Justice of India can decide this. President's approval is government's approval. See, here also, can the President reject this permission? No, they will not reject this permission. It's not possible. It is just a ceremonial request that you request the President that, sir, please, with your permission, I am doing it. Otherwise, they can't reject here. But let's say seat of Supreme Court. Now the Supreme Court says, we want to go to Goa and sit. Please make a new building. The government can say, sir, right now we don't have money. We can't make a new building. Sorry. Please, 6 months later. So based on those extreme situations, the request of the Chief Justice can be denied also. Understand the logic? Otherwise, normally, why would it be denied? So under extreme circumstances, the request of the Chief Justice can be denied. That's it. That's all as far as the basic information on Supreme Court is concerned. We are done with the basic information. Now, coming to the jurisdiction, area of influence, the powers of Supreme Court. So what exactly are the powers of Supreme Court? First up are those cases that go directly to Supreme Court. We call those things original jurisdiction. Article 131. What is this original jurisdiction? See, when it comes to some kind of cases, those cases can only be filed in Supreme Court, and you can directly go to Supreme Court. For example, if let's say somebody has attacked you or somebody has robbed you, you go to a lower court to file a case. You cannot go to Supreme Court to file a case. It is not allowed only, right? But in certain situations, you are allowed to directly go to Supreme Court, and you can go only to Supreme Court. No other court can adjudicate, take up the case. This is called original jurisdiction, right? I'll give you an example. Example is federal disputes. So what are these federal disputes? Any dispute between center versus state or state versus state or center plus state versus few more states, any kind of permutation combination that you think of. So if there's a dispute between the government of India and West Bengal, you cannot go to Calcutta High Court, Delhi High Court, Bombay High Court. You have to go to Supreme Court only. There is no other alternative. Clear? Can you give me any other example wherein you can go only to the Supreme Court and no other court? Water disputes, no. It goes to tribunals first. Fundamental rights is not the answer. For fundamental rights, we can go to high courts also. Please. Not a single right. One person mentioned right answer so far. Okay, now some of you are mentioning right answers. Terrorism, land dispute, financial, what is this? Let me repeat one more time. There are certain cases which only Supreme Court can take up because of its superior position. Okay, like there are certain things which only your father can decide in the family because of his superior position, or a mother can decide because of a superior position. That's it. No other court can decide. Are you clear? Secondly, you can directly go to the Supreme Court. No need to go to some lower court. The answer is Article 71, which is the election disputes dealing with the election of president, vice president. Do you remember this? And I am saying again and again, fundamental rights is not the answer. Stop writing fundamental rights. It is not the answer. Are we clear on this? Okay. Why? Because when your fundamental rights are violated, you can go to High Court also. Exclusive part is not there. It is direct. I fully agree, but not exclusive. Here, the concept is direct and exclusive. Okay. So this is these are some examples of original jurisdiction. And let me remind you, even high courts have the power to interpret the constitution. Even high courts can cancel central government laws. Let's remove this dilemma in our mind. High courts have the power to cancel central government laws. High courts have the power to interpret the constitution. Are we clear on this, everybody? Okay. And here it is only state, not UT. Union territories are basically territories belonging to center. So if there's a dispute between UT and center, you'll go to High Court first. For example, UT of Delhi versus center. You go to Delhi High Court first and then Supreme Court. State here means state only, not the union territories. Okay? Moving on. Question. I just explained the answer only of this question. Anyway, so solve this question. 45 seconds. Please mark the answer. Okay, easy question after I explained specially. Which of the following are included in the original jurisdiction? Dispute between the government of India and one or more state. Of course, one is apart. Remove these two. Then 4, a dispute between 2 or more states. Of course, is correct. C is the right answer. A dispute between government of India and UT. It goes to High Court first, Supreme Court. Clear? So not exclusive or direct. Second, a dispute regarding the elections to either House of Parliament, MP, MLA or MLC. MP, MLA, MLC election dispute. We go to High Court first. And then we go to Supreme Court first. Okay. Clear on this? Yashika, come on, be serious. You can't ask this question, UT versus state. You have to tell me the answer now. If there is a dispute between UT versus state, where do we go to? Tell me. UT versus state dispute. UT belongs to, what is the meaning of UT? Union territory. A territory belonging to the union, right? UT is a territory belonging to union. So it is not some UT versus state dispute. It is a dispute between center and state only. What is UT? UT is a part of center, an area in the country which the center directly administers, directly controls. Clear on this? Center versus state. Anyway, we'll discuss UTs later on. So we have seen one thing. There are very few matters which you can directly approach the Supreme Court for, very few limited matters. Normally what happens is this: appellate jurisdiction. Read the word here, appellate. Appeal. Right? So I hope you know appeal. We file a case in the lower court, then appeal in the high court, appeal in Supreme Court. So basically, most matters that go to Supreme Court are by way of appeal only. You can't directly approach the Supreme Court. So how do they function? Now, at the lowest level, we have these courts that we know as what kind of courts? Subordinate courts. Yes or no? The lowest level. If there is any issue, we approach here. Next, if we are not satisfied with the decision of the subordinate court, where do we go to? We go to the high courts in the state. That's the second level. If we are not satisfied with the judgment of high court, where do we go to? Then finally we come to the big boss, the Supreme Court. Okay. Just to give you an understanding, in the lower courts, there are various types of lower courts. We'll discuss that later on. We only have one judge. But in high courts, there is a concept of SJB and DB. I'll explain. Don't worry. Don't worry. SJB stands for a single judge bench, and DB stands for division bench. Meaning 2 judges. So what happens is that in a high court, you will file a matter. It firstly goes, say matter is filed here, case filed. You are not happy with the judgment. Eventually you go to a single judge bench, one judge. He decides, not happy, you approach him or these 2 judges. Division bench, 2 judges. Bench means group of judges. Like lawyers, group of lawyers is called a bar, not the bar you are thinking of. Bar means group of lawyers. Okay? Bench means group of judges. Difference. Now, if let us say there is some constitutional matter being heard by the High Court, because we know High Court can also hear constitutional matters. So just to point this out, for constitutional matters, three-judge bench, three judges. Okay. Now the matter goes to Supreme Court. Now in the Supreme Court, there is no concept of a single judge. Every judgment in Supreme Court is decided by at least two judges. So we have DB, division bench. There is no case in the Supreme Court which will be decided by a single judge. Every case, at least two judges decide. Or we have a three-judge bench called priority bench, PB, for priority matters, important matters. Three judges. And finally, if the Supreme Court is going to interpret the Constitution, then it is a constitutional bench, CB, constitutional bench. This should have at least 5 judges. So any matter which the Supreme Court decides, which is an interpretation of the Constitution, should have at least 5 judges, 5 or more. It can be 5, 7, 9, 11, 13, right? So on and so forth. Are we clear? Now, just to also address your concern, who decides which case goes to which judge? In the Supreme Court, who decides this? The Chief Justice. Okay? The Chief Justice has the task to decide which case goes to which two judges. Clear? That is why the Supreme Court Chief Justice is called Master of Roster. Master of Roster. Roster is a register where you allocate the cases. So, like in your school days, you had the register. Same thing here. So, Supreme Court CJI is called the Master of the Roster because he is the one who allocates the cases to various judges. Clear? In fact, that's his only special power. Otherwise, he has no other special power apart from the collegium. Okay. Now, so here, from here, the matter comes here. The Supreme Court can decide based on the matter what kind of matter this is and can allocate it to a bench. This is called appeal. This is what is appeal here. Appeal in High Court, and this is the appeal in Supreme Court. Okay. Now, one big misconception that we have is that any person can approach Supreme Court by way of appeal. No, you can't. Sorry. Once High Court gives a judgment, it is not some kind of right that you have to approach Supreme Court. Right? Basically, this appeal in Supreme Court is based on some conditions. Based on conditions. What are the conditions? Condition number 1. Article 134 capital A. This basically says that if, let's say, High Court gives a judgment and you are not happy with the High Court judgment, you can ask the High Court that, sir, please allow me to approach the Supreme Court. I don't like your judgment. If the High Court judge says you want to try there, okay, go try there. If the High Court allows you, then you can appeal in Supreme Court. Otherwise, no. Okay. This is called when High Court gives a certificate of appeal. So you have to get this certificate from the High Court. You can start crying, roll down the floor, there only, start stamping your feet and all, keep on crying like some Indian Idol contest, and then maybe they'll give you the certificate. Clear? Or let us say High Court does not give you a certificate, says no. But there are certain situations wherein you are allowed to appeal in Supreme Court. Those situations are Article 132, Article 133, and Article 134. So one very simple thing would be, if there is a constitutional matter, which court is the final court of appeal? Which court is the ultimate interpreter of the Constitution? Supreme Court. So if there is any matter pending in High Court, let's take the example of hijab case, right? So hijab case which was there in Karnataka, that was given by a 3-judge bench in the Karnataka High Court. People are not happy, they went to Supreme Court. There you don't need the permission because it's a constitutional matter. If the case involves interpretation of the Constitution, you have every right to go to Supreme Court. Article 132. What is this? Interpretation of Constitution. That's it. Or if the matter is a civil matter involving a very important question of law, some very important civil matter is there, then you can go to the Supreme Court. Article 133 for very important civil cases. Clear? And finally, Article 134. In criminal matters, if High Court has reversed the judgment of a lower court and has given you a punishment of at least 10 years, mind you, not less than 10 years. If the High Court gives you a punishment of at least 10 years of jail, then you can approach the Supreme Court. Otherwise, no. Sorry. And this 10 years was earlier death sentence. It has been reduced to 10 years now. Basically, in 1970, there was a bill which was the last private member bill to be passed in the country. That bill was called Supreme Court Enlargement of Criminal Appellate Jurisdiction. So with that bill, we enlarged the appellate jurisdiction of the Supreme Court. Now Supreme Court can take up cases where the High Court has not just given death sentence, but even life imprisonment, 20 years jail, 15 years jail, 10 years jail, etc. So that was a law not important, but it was the last ever private member bill to be passed in the country. Supreme Court Enlargement of Criminal Appellate Jurisdiction Act, 1970. So these are the only situations wherein you can approach the what? Supreme Court. Clear on this? So this is with respect to all these 4 criteria. These are the only 4 criteria where you can approach the Supreme Court. Otherwise, sorry, your High Court judgment is the final judgment. Whether you like it or not, we don't really care. Okay. I'll repeat once again. First thing would be, if the High Court allows you, of course, Article 134 capital A. Number 2, if the matter involves interpretation of the Constitution, then you are allowed to go to Supreme Court. Number 3, if it's an important civil matter, right, then of course you are allowed to approach the Supreme Court. Here, important civil matter could be a land dispute between 2 communities, big businessmen and their disputes on ownership of business, etc. Such kind of disputes. Ratan Tata, Cyrus Mistry dispute, all these things. These are basically disputes of a civil nature. Tax disputes involving Vodafone, etc. Civil nature. Lastly, is if the High Court has reversed a lower court judgment and has given you at least 10 years of jail sentence, then you will be allowed to go to Supreme Court, file an appeal against the High Court's judgment if you don't like the High Court judgment. This is how the appeal works in the Supreme Court. Clear? That's it. Okay. So this is there, and let me also clarify, you cannot decide which bench you can file a case. The court decides. Are we clear? You cannot choose all these things. So if you file a case and you say, no, I want CJI to take up my case, sorry, that is not in your own control. Okay, the CJI will decide to which judge your case goes. And for every other kind of case, the end of story is High Court only. You can't go to Supreme Court. So please be happy with the High Court's judgment. Clear? Okay. Now, so I have just mentioned this statement that we cannot go to Supreme Court in most cases. But we find that even if somebody gets 4 years jail, 5 years jail, celebrities, they somehow end up in Supreme Court. How? After all other matters end up in Supreme Court. How does this happen? Right? Of course, there should be some room left, some scope. What if the High Court deliberately gives you 9 years, 11 months and 29 days of punishment? Then what? Now, things can go wrong. Or all these rich people, they always go to Supreme Court. How? Because there is an option given to you that if the High Court has denied certificate to you and your case is not fit for appeal, and High Court has denied certificate. You filed a case, the matter went to High Court, and High Court said, sorry, we will not give you certificate, my judgment is final. Then what do? What if the judgment is wrong? You can do is you can go to the Supreme Court and file a petition, request. You can request the Supreme Court. Okay? That is called special leave petition. Leave means permission. Leave here does not mean leave the court only. Leave means permission. So what we do is we will take the permission of Supreme Court. We'll say, sir, Supreme Court, my lords, High Court is not giving certificate. My case is very important. You please take up my case. I feel justice has not been done in High Court. Please, sir. Yes, I know my matter is not a constitutional matter. My punishment is only 5 years. But still, I feel justice has been denied to me. Sir, you please take up my case. If the Supreme Court feels, it can take up a case. If it feels. So this is not your right to appeal. This is your right to request. to take up the case. Supreme Court may. What is may? Optional. May grant special permission to appeal from any judgment, any order, in any cause, any matter passed or made by any court, any tribunal in the country. So Supreme Court can allow for this. It is not your right. Don't think that I will get this case in Supreme Court. You can only request the Supreme Court. It may be accepted, it may be rejected. Are we clear? This is Article 136 used by all our great lawyers. That is why all the matters of these rich elite people go to Supreme Court because of this. All you have to do is prove that your case is very, very important. Are you clear? Okay. Article 136. Now, also think of it. Why would Supreme Court allow you to file a case? Are they saying that judges of High Court are useless? Of course not. But there are some reasons also. Reasons for allowing special leave petition, SLP. What are the reasons? Acha, what do you think? Tell me. What do you think should be a reason that Supreme Court, despite your matter not important, despite it is not a constitutional matter, despite High Court saying judgment is final, don't waste time, go, still you are being allowed? Okay. No, death sentence it's allowed, na? Directly. Judicial error, possible. Punishment is very strict, possible. Okay. These two things are there. New facts come to light, possible. Okay. Some of you are saying that if the verdict is biased, etc. Fair enough. Fair enough. So one thing is, grave injustice has taken place, meaning the judgment was not fair, very harsh punishment, or new facts, new evidence comes to light. Something new comes to light. Okay. Or violation of principles of natural justice. This has happened. This has happened. What is the meaning of principles of natural justice? A new phrase for you. Principles of natural justice. Those who attended the class earlier, they would know. For others, first time information. See, this concept called principles of natural justice is not just in India. It is not mentioned in any article. It is a concept accepted worldwide in every country. In general jurisprudence, this concept is accepted that we have to follow some very basic etiquettes of giving judgments. Number one, nema causa in judex sua. Forget that. I'll translate it. No one can be a judge in their own case. Are we clear? No one can be a judge in their own case. This actually is the right that everybody has against bias. Imagine you go and file a case in the court, and now you come to know that the person against whom you have filed a case, his best friend from school is a judge sitting there. How can justice be done? And let me remind you, even if the judge says, no, I'll be very fair, justice should be done. It should be seen to have been done. It's way more important. Right against any kind of bias. So judges should not be involved with either of the litigant or party. If it is found that judge knew any of the party involved, then sorry, your very first principle, the most basic principle of natural justice is being violated. Right against bias. That is why there's a term for it. A term called recusal. What is recusal? Recusal means, let's say, the Chief Justice comes to me and says, okay, now this is your case, take up this matter to judge bench. The case is filed in front of me. When I see the person, I say, oh, 20 years back, we used to share the same college, same school, friends. Now, I have come to know that I know one of the persons who has filed the case. The other person may always feel things are not fair. So, I will take my name back from the case. I'll say, sorry, I cannot be a judge here because it won't be fair. That's called recusal. When judge takes back his or her name from a case to ensure fairness. Are we clear on this? Everybody? This can happen at any point of time. Lower court, high court, Supreme Court, that's it. Now, second point is audi alterum partem, meaning here both sides. Here both the sides. So think of your situation in your own house. All those elder siblings, you would understand this, that if your parents went out and you harassed your younger sibling, because that's your right to harass your younger sibling, the moment the parents came, younger sibling started crying immediately, right? And now your parents will come and directly beat you. They won't ask you also what happened, what you did, nothing. It is wrong. Next time you tell them, you are violating the principles of natural justice. I have a right to be heard. Second principle, every side, every party has to be heard. You cannot simply say, I have heard your version, that's it, final, judgment comes. No, judgment cannot be given without hearing both the sides. Now, when you say this, your parents may beat you more, but at least no, they'll be happy that you know polity. So that's there. Now, the third principle, it's a more recent one. Give reasons for judgment. Again, the same story. When your parents scold you, beat you, you ask them, why are you beating me? Why are you scolding me? I have a right to know why I'm being punished. Again, at your own risk. Make all these statements at your own risk, please. But these are all principles of natural justice. They should be followed. Without this, justice is not fair. It is unfair completely. Without hearing both the sides, without giving you an opportunity to represent yourself, without even telling you why you're being punished. We are punishing you. So that is called a violation of natural justice. So normally, these two things will not happen. Because when you file a case in court, there are two parties, party 1, party 2, or litigant 1, litigant 2, A, B. The judge will hear both the sides. Okay. Normally, first one can get affected because it may be possible that the judge is biased in favor of a party. Here, party means a person who has filed a case in court. Don't think political party. Where has BJP and Congress come from? No. So this is with respect to principles of natural justice. Are you clear? Now, whenever we see this term, we will understand what we are referring to. Here, both sides of arguments. What is there to explain here? Both the sides, meaning there are two people who have gone to the court, right? How can one person go to court? Against whom? Against somebody? I have to give both the people equal chance to express their opinion. Now somebody says, first point, repeat. If a judge knows any of the person who has filed a case or against whom a case is filed, then the judge will never be fair. Imagine you are the judge, a person comes to you and files a case against your best friend. Do you think you should sit for that judgment, yes or no? Is a question I am asking you. Of course not, because your judgment will never be fair. Its original language, nema causa in judex sua. That is the original language. You can simply search for principles of natural justice. You'll get the first two, mug up those, impress random people. Nobody cares. But this is the meaning. Okay. SLP is very costly. Common man cannot afford. Who is saying common man can afford all these things? Are you crazy? We can't afford all these things. It is meant for rich people only. Of course. No, I'm not saying all this. Sorry. Justice is there for everybody in the country. Supreme Court says so. Don't make me say all these things, please. Okay. Swarufuddin, that's why I said, I am not saying, I take back my words. I am not saying why only for rich. Justice is there for everybody. Why only rich people? You can also approach the court. Hire any lawyer. Now, of course, the whole point comes down to hiring the best possible lawyer. So it's just like, say, coaching institute. You can go to any coaching institute. The better the institute, the more the fees. So you pay for what you get. So if you're paying for the best possible lawyer, they'll ask you, if you want my service, 25 lakh rupees per hearing. Per hearing. Meaning what? When you go to the court, 1 day of hearing, he will charge 25 lakh rupees from you. 1 day of hearing, which may be 5 minutes also. And there are so many hearings. Vamsi, yes, judges take recusal. Of course. Devansh. How the first point of PNJ is validated? First point, it will not be validated. Basically, you have to prove it. But you are requesting the Supreme Court that, sir, High Court has not given justice. Prove it. It's not Supreme Court's problem. It is your problem. You have come to Supreme Court. Are you clear? So that's there. Actors will not use all this. Their lawyers use all this. That is the quality of a lawyer. How to use all this. Okay. That is what you have to collect in the evidence. So don't think that evidence is placed in front of you. This is the advantage of a good lawyer. He knows the law inside out. And he will tell you how to use, what to use, when to use, how to collect the evidence, how to contact police. Have you not seen movies? रोहित सर, सुप्रीम कोर्ट कितने साल का सजा देता है? कितने साल? Death sentence also. Guys, there is no punishment as such for violating the principles of natural justice. If something happens Then maybe the parliament can initiate removal proceedings. Maybe, right? Maybe. This is SLP. Now, coming to revisory, and let me also remind you one thing. You know, very few cases actually reach the Supreme Court because of very strict appellate power. But you will be surprised, out of roughly 70,000 cases pending in Supreme Court, 80% are SLPs only, where Supreme Court has accepted a case which did not deserve to be in the Supreme Court. That's there. Now, coming to revisory jurisdiction. Revisory jurisdiction. From the word revision, Article 137. So as I was saying, that Court of Records have the power to take up cases or revise or review their judgments. Revisory jurisdiction. So let's read first. Supreme Court shall have the power to review any judgment pronounced or order made by it. Let's come here. So now you have gone to Supreme Court by way of appeal. We are here right now. Focus now. We are here right now. When you appeal, judgment comes, Sabrimala case. You are not happy with the judgment. What do? Remember your school days. In your school days, your answers were checked. You were not happy with the answer, with the marks. You went for what? Re-evaluation. You went to the teacher saying, sir, please, more marks, ma'am, please, more marks. You are filing the case again in Supreme Court, requesting the Supreme Court. This is called review petition. Again, request. You will request the Supreme Court that, sir, my lords, you gave a very good judgment, but sorry, I am not happy. Please, can you relook? Can you check your judgment again? Of course, you have to give your facts. Why you're not happy? What do you think is wrong? Try to convince them. Okay. So if you are filing a case, a judgment comes against you, you can again file a case in Supreme Court. But this time you can only request the Supreme Court. Okay? You can only request the Supreme Court. This is what is called a review petition. A review petition must be filed within 30 days from date of judgment. Within 30 days. Okay. You can't say, sir, in 1974 decided this, now I have come here, sir, please. No. And number 2, review petition may or may not be accepted. Okay? It is not that it will always be accepted. No, you have to convince the judge that, sir, last time when you gave the judgment, you missed on that fact. How do you convince your teacher that, sir, I wrote this answer, see, this word is there, the steps are there, please, 1 more marks, 2 more marks. It's just your convincing ability. If you can convince the judges, then review petition can be accepted. The very good example is Sabrimala case, where the review petition was filed. What if after filing of review petition also, the judgment comes against you and you are still unhappy? Then what do? Constitutionally, you can do nothing after this. That's it. This is the last step which is mentioned in the Constitution. Last. End of story. Now, judgment is final. It cannot be questioned again. You have to go with the punishment. Clear? But in 2002, Supreme Court said that, okay, you are still unhappy? No problem. We are giving you one more chance. Come on, try once again. This is a concept called curative petition. This concept has been, this is an innovation by Supreme Court. Innovation by Supreme Court. In the year 2002, there was a case of Ashok Hurra versus Rupa Hurra. In this case, which went to Supreme Court said, try once again. This is applicable after failure of review petition. Are we clear? If your review petition fails, constitutionally, end of story. But try once more. Curative petition. This is, as I said, not mentioned in the Constitution. Are we clear? This is not mentioned in the Constitution. It is a very rare situation where it will be allowed. Okay, normally it will not be allowed. You have to prove that the courts have again and again made some mistake. It is almost impossible for the courts to make so many mistakes at the same time. Not possible. So this is called curative petition. If you are still not happy with the judgment of the Supreme Court, then what do? Sit at home and cry, because nothing can please you. That's end of story. We have to stop at some point of time. Then what you can do? Accept the punishment and go and seek mercy from the governor or president. That's your only hope left. Judicially, the journey of your case is over now. We have to stop at some point of time, right? We cannot keep on giving you chances. So this is the last thing that we have. Nothing beyond that. Sorry. See, the idea of curative petition comes from Supreme Court only. Supreme Court says that judiciary can go to any extent to meet the ends of justice. It's very important. And courts are under the obligation to correct or undo any kind of wrong, even if the wrong has been done by court only. So that is why they allowed for this concept called curative petition. That's it. This is how you appeal. Clear on this? This is all about the appellate jurisdiction. This figure should suffice and nothing more is required. We have too much of information on the appellate jurisdiction. Solve this question came in 2021. Okay, so 39% have got this answer correct, but there is a small problem here. What I have marked as correct is A, which is UPSC's answer key. But frankly, the right answer for this question is not A. It's actually C. Right? I'll tell you why. So, what is the question? With reference to Indian judiciary, any retired judge of the Supreme Court of India can be called back to sit by the Chief Justice with prior permission of President. Yes or no? This is correct. Correct. Remove this. No problem. Article 128. We all know this. Now, second question, a statement. A High Court in India has the power to review its own judgment as the Supreme Court does. This statement is actually correct. This is actually a correct statement. Let me remind you. Why? Because Article 215, High Courts are court of records. Every court of records has the power to review its own decision. This question asked in 2021 was actually based on a Kerala High Court judgment of 2020, where Kerala High Court has actually said court of records, the same concept. Still, UPSC, when its answer key came, the UPSC answer key, answer is A. Why? Because in the Constitution, only Supreme Court is mentioned, which is Article 137. Even then, they should have mentioned with reference to Indian Constitution. If the word Constitution was mentioned, then maybe we could have accepted this answer. But sadly, this is a very poor, very shoddy approach by UPSC. A current judgment passed last year, how can you have a wrong answer? But this is life. Are we clear? Nothing is fair. One or two questions will always be there. Please don't worry. These things will always have an option. Okay. So that is all as far as this question is concerned. How can UPSC make mistakes? They are human beings, just like you and me. Okay, don't think that they are some amazingly intellectual people. They can make mistakes. Mistakes happen. In fact, at least now you know that UPSC answer key is wrong, some answers are wrong. 10, 20 years back, UPSC did not even reveal the answer key. You had no idea. You had no idea that the answer was wrong. Okay. Yes, that is why the answer key is released after the entire examination process is over, so that you cannot challenge. Oh, Karthik, come on, calm down. That is not the reason why aspirants can't crack the exam. It's just one question. If your selection depends on one question, then it's a difficult selection. That is why I say score 120 plus marks. Be on the safer side. Akanksha, Article 205 does not directly mention it. It only mentions court of records. But Article 137 directly mentions that Supreme Court can review its own judgments. Yes, Neha, that was also wrong. No, K. Navina, it depends on the question. Abhiraj, why this question? Come on, be serious. President's Mercy Power, Article 72. Remember? Okay. Yes, Shalu, it will take place. It is... Nitesh, whether it is mentioned Lakshmikant or not, that is actually a correct statement. Lakshmikant also has it right. That statement is actually correct, but what can we do? This is UPSC. So let's ignore that. One or two things will happen. No worries. Okay, moving on to advisory jurisdiction. So, Supreme Court also advises the government. Article 143. Advisory jurisdiction. Okay. Now, if you have seen this movie, Three Idiots, or the Tamil version starring Vijay, Nanban was the movie, if I am not wrong. So, in that particular movie, if you remember the scene where Amir Khan or Vijay to Ileana or here Kareena Kapoor, they love giving free advice, right? This free advice on his own, this is not how the advice works for Supreme Court. In case of Supreme Court, you will only give advice when you are asked. Are you clear? Not on your own. Don't act over smart, is what we would say in the nicest of language. So basically, what happens is, when it comes to the president can seek advice from Supreme Court. Firstly, can seek a legal opinion on general matters. General matters. Or it can also seek an opinion on the interpretation of laws. Now, when the president seeks any advice or government seeks any advice from Supreme Court on legal matters or general matters, here Supreme Court may or may not give the advice. But if the government seeks the advice of Supreme Court on interpreting any law, any constitutional provision, then here Supreme Court must give advice or opinion. It is mandatory here. Are you clear? So this is there. Anyway, just to note this point, advice given by Supreme Court is not binding on the government, meaning the president. Clear on this? So this is there when it comes to giving any advice. So see, why it is binding here is because Supreme Court is the interpreter of laws. So when the government comes and asks you interpret this law, you have to. And such advisory jurisdictions, it's not a court case. It is called presidential reference, sometimes referred to as RE. So whenever you find this word mentioned, you can understand it is not some court case filed. It was the government seeking some opinion of Supreme Court. A very good example is the third judge's case of 1998. Third judge's case was not actually a case. It was basically presidential reference. Are you clear? So this is there with respect to advisory jurisdiction. Why president take advice, Sakshi? Arish, Madam, president means council of ministers. How many times do you want me to embarrass the president by saying again and again that he has no real powers? It is a government. Okay. So anyway, that is all as far as Article 143 is concerned. One more thing, this advice must be given by at least 5 judges. Minimum 5 judges. Okay, Shruti, but there is AGI present, then why take advice from Supreme Court? Very valid point. Attorney General will give you a legal opinion, but Supreme Court gives you an authoritative legal opinion. For example, if I want to file a case in the court as a government of India, people's money also get wasted, right? Because if the government files a case, they have to pay the Attorney General. How does government pay the Attorney General? From the CFI, where our taxpayer money is there. So the whole point here is that if I want to file a case in the court, I will firstly ask Supreme Court only that, sir, my lords, this is a matter. Should I file a case in the court? What do you think? And the court can say, don't file a case, you lose it. You will waste people's money. Don't file. And then I won't file a case. Clear? This is there. Secondly, for example, the third judge's case. The government was confused on what exactly is the procedure of transferring the judges of high courts or even appointing the high court judges. It went to Supreme Court saying, sir, you please clarify what is meant by Article 124 Clause 2. How to appoint judges? Please interpret Article 124. And Supreme Court, in the third judge's case, interpreted Article 124. It was not some Supreme Court judgment. The government went to Supreme Court to ask it, please make us understand how this collegium will work. And then the Supreme Court gave the advice. Are we clear? This is an example of advisory jurisdiction. Okay? Everyone okay now? Governors have no such power with respect to the high courts. Please, it is meant for Supreme Court only. If there is any such power which is there for the governor, I'll tell you. No such power. Okay. Before we take a break, let's solve one more question and then we'll take a long break for full enjoyment. Please. So slightly lesser time. Easy question. Anirudh, what is your question here? Oh, sorry. My bad. I marked the... Mark your answer again. I'm so sorry. Take the poll again. A lot of you must have gotten this wrong now. Please mark the answer again. I was reading somebody's question. I, by mistake, marked this incorrectly. Yes, leaderboard gets affected now. Extremely sorry. Still not 100%. Okay, consider the following statement. Supreme Court of India tenders advice to the President of India on matters of fact or law on its own. Of course, it is wrong. When nobody asks you, we don't want free advice. One is wrong. This is gone. This is gone. If he seeks such an advice, of course, 2 is correct. B, 2 only is the right answer. Only if the matters relate to fundamental rights. Not really. 2 is the right answer. That is correct. Okay. That's all. Let's take a quick break. Be back at 6:56. Leaderboard now makes no sense. There'll be some issue with the leaderboard. But anyway, Natarajan, Priya Singh, topper still. Others follow. Those who marked A as correct would not have marked other questions. So I don't think the ranking will get affected, frankly. Done? Okay. Anirudh sending, what is Supreme Court doing with gay marriage cases? No, it cannot push the legislature to make laws. That's not possible. It can direct the legislature to make laws. Till then, it can declare that gay marriages are allowed. That is possible. That is possible. But it cannot force the parliament to make a law on that. It can simply interpret that under the Marriages Act, man and woman would also include man and man, woman and woman. That they can interpret. But you cannot force the parliament make a law. That's not allowed. Shalu, no, Shalu, that is not appellate jurisdiction. Okay, Nitesh, fully accepted. Okay, let's take a break, guys. Be back at 6:57. And we'll continue our discussion further. Break, please. Welcome back, guys. Let's continue. Uh, yes, Anirudh, that would be seemingly like modifying the provisions, but that is what it is, right? Interpretation. Where is the limit? There is no limit. Okay, so now let's also look at some other kinds of jurisdictions, like Shalu had addressed this question of yours. It is not called appellate jurisdiction. It is not appeal. Now, writ jurisdiction. So we'll discuss more on this when we study fundamental rights. But just for now, Article 32 of the Indian Constitution talks about writ jurisdiction. What is the meaning of writ? Writ means order. Writ means directive. Order or directive is called writ. Now, these orders are issued to protect fundamental rights of the people of the country. And also, Parliament can increase this power by a simple majority. That's there. This is called writ jurisdiction. Orders or directions or directive issued by Supreme Court to protect the fundamental rights of people can approach Supreme Court directly. Okay. So this is the writ jurisdiction. Again, when I am saying this, I think for the third or fourth time today, I am writing articles for the benefit of people who want to study. Towards the end of the lecture or the module, I'll mention the important articles. Don't ask this question again and again. It makes no sense. In fact, it shows to me that you're not paying attention in the class. That's what it portrays completely. Please, you're not some customer. Behave like a student. You're a student, not a customer, right? Please focus in the class. Now, just one point. Supreme Court can be approached directly and can be requested to issue a writ to protect the fundamental rights. If we can approach the Supreme Court directly, why is it not a part of original jurisdiction? Right, please. Hear the question first. If we can directly approach the Supreme Court asking the Supreme Court to issue a writ, why is it not an example of original jurisdiction? Okay, fair enough. A lot of you are writing it. Not exclusive. Very good. It is not exclusive, the second part, because even high courts can issue such writs. Article 226. Are we clear? High courts can also issue such writs. That is why it is shared, not exclusive. Original. Where is original? Original. Exclusive. Okay. That's it. Now, there are a lot of writs that we have: habeas corpus, mandamus, prohibition, certiorari, quo warranto. We'll deal with all these writs under fundamental rights. Details during fundamental rights. Okay, that's there. Now, some other important provisions. Number one, Supreme Court's jurisdiction can be enlarged by Parliament. It's very easy to enlarge the power of Supreme Court by law. Please take note of this point. To increase the power of Supreme Court by law, simple majority. To decrease the power of Supreme Court, special majority plus the consent of half the states. I'll repeat. To increase the power of Supreme Court or High Courts, simple majority. To decrease the power of Supreme Court, a special majority plus half of the state's consent is also required. It is mentioned where? Mentioned in the topic that we studied, types of majorities in the parliament. Okay. Now, Article 139 capital A. Did you see recently also, what is this comedian's name who was also in some online Big Boss thing? This guy who was already married but still was flirting with other people there, who keeps on passing all these religious jokes. Munawar Farooqi. Yes. Right. Okay. So this guy, Munawar Farooqi, so there's some case against him of defamation, some Hindu gods, etc. So multiple places the case was filed. Supreme Court has recently directed that send all the cases to Indore, where he resides, probably, I'm not sure. So this basically means that Supreme Court can direct other courts to transfer cases. It's very common. For example, in this Nupur Sharma case, Nupur Sharma, remember this lady who was caught on live TV making some remarks. Now, Nupur Sharma, multiple cases were filed against her across the country. So she had gone to Supreme Court asking Supreme Court that Supreme Court, all the cases are one case only. Please send all these cases in Delhi because I live in Delhi. It's easy for me. So Supreme Court can actually transfer cases from one high court to another or to itself. It is allowed. Now, why will it do this? Number one, on its own, that is called suo motu. What is the meaning of suo motu or suo motu? MOTU, same thing. On its own. Second, if Attorney General requests, so let us say Attorney General has to travel to multiple places, right? So it will only increase the burden on the government. So Attorney General can simply say, sir, I have to go to various high courts. Why don't you transfer all the cases in Delhi High Court only? It will be easy for me. Or Supreme Court only. There. Or number 3, if the litigant, party involved, they request. Okay? Like say Nupur Sharma, Munawar Farooqi. This can be done to ensure fairness. Like in the case of the fake encounter in Gujarat, the case was transferred from Gujarat High Court to, say, Rajasthan High Court. Or in the Bilkis Bano case, the case was transferred from Rajasthan High Court, Gujarat High Court to Bombay High Court to ensure fairness also. Yes, Jayalalitha case also transferred to Karnataka High Court from Tamil Nadu High Court. So sometimes cases can be transferred from one high court to another to ensure fairness of the case. because not that High Court judge is corrupt, no, but because there can be lot of pressure on the High Court judge, right? So that is there. Shruti, by giving bribes? No. Why by giving bribes? By requesting, not giving bribes. And lastly, Article 141, the law declared by Supreme Court is binding on all the courts. Are we clear? Whatever Supreme Court says is binding on all the courts in the country. So no High Court, no lower court can go against Supreme Court. Of course, Supreme Court is the boss. Makes no sense, right? Okay, Navina, read this article, please. Supreme Court is the big boss. Supreme Court can reverse a decision of High Court, cancel a decision of lower courts. It does not really matter. What Supreme Court says is binding on all courts in the territory of India. Clear? Now, one thing that we have always seen and observed, you must have seen this term at least, called activism. For example, judiciary interfering everywhere, telling government what to do, telling parliament what to do, right? How? How does the judiciary get this power to interfere everywhere? There is a constitutional provision which allows the judiciary to interfere everywhere. Article 142. This is what is the source of judicial activism. I'll read the article for you, and you can realize the wordings of this article are such that let's read now firstly, then I'll help you understand the words one by one. See, the Supreme Court, in the exercise of its jurisdiction, may pass such decree. Decree means conclusion, conclude. May pass such decree or make such order as is necessary for doing complete justice. So Supreme Court wants to do complete justice in any cause, any matter pending before it. It can pass any order, can make any conclusion, and any conclusion so passed or order so made shall be enforceable throughout the territory of India. Are we clear? This is Article 142. Very, very important. We'll discuss activism once we study issues of judiciary in detail, but this is a source of activism. This is where Supreme Court gets this power. It can simply say, Article 142 allows me to give any kind of judgment because my purpose is to give justice to people, right? This is where the Supreme Court gets the power to give directions to anybody, to the Prime Minister, to the Parliament, to you, to me, everyone. Are we clear on this? Article 142, judicial activism. More on activism later on. Just understand that if you are having any problem, ignore this word. Ignore this word. Not relevant right now. Just look at this article only. It's very simple, English language. That Supreme Court can give any kind of order on any matter pending before it to ensure complete justice. Whether that matter lies with the Parliament, lies with the government, we don't care. Clear on this? So this is with respect to Article 142. Now I'll give the examples on this later on. Simple example, Sabrimala. Supreme Court gave the order to allow entry of women in Sabrimala. What is the expertise of Supreme Court? Parliament should make a law allowing entry of women in Sabrimala or not allowing entry of women. So this is an example of how Supreme Court gives orders. And lastly, Article 145, with the approval of the President, Supreme Court can make rules and regulations for the functioning of the court. So approval of President is just a formal approval. It is always given. So Supreme Court makes its own rules. How the House should function is decided by Supreme Court only. Are we clear on this? And one more thing, minimum number of judges to decide on matters of interpretation of the constitution. Meaning what? Constitutional bench. So we have seen this earlier also. What is a minimum size of a constitutional bench? Tell me. 5. It is 5. Or even matters of Article 143, advisory jurisdiction. Minimum 5 judges. It can be more also, but minimum 5. And lastly, all decisions to be given by majority judgment. So Supreme Court gives decisions based on majority. So like 2:1, 3:2, 4:1, etc. This is called majority. Now, if 1:1 happens, we call it split verdict. Is it possible? Remember, division bench, 2 judges, 1:1. Then matter sent to a 3-judge bench. Are we clear on this basic information with respect to the Supreme Court? We are done with the Supreme Court. Now, high courts. So many high courts in the country. How many high courts in the country? Please write. Okay. We have basically 25 high courts in the country. Presently, 25 high courts. In high courts, you have total 1114 judges. In total, you have 1114 judges. Some of them are permanent and some are called additional. They are for maximum 2 years only. Okay, so we have around 840 permanent judges and the remaining 274 additional judges. Anyway, also let me just remind you of this 1114 judges. The vacancy in high courts till the 1st of April was 331. 331 seats are vacant in the high courts. This would roughly amount to 1114. Less than 30, around 0.3% less than 30. 29.7, roughly 29.7172%. Roughly 29.7% vacancy. That's almost 30% seats are vacant. Anyway, we'll discuss all this later on. So this is there with respect to high courts. High court for each state. So every state has one high court. Are we clear? It may not be located inside your state. It is possible. It may not be located inside your state, but every state gets a high court. And we can have a common high court for 2 or more states also. Additional judges, I just gave a reference here that additional judges are judges who are appointed for 2 years only. If they perform very well, we make them permanent, or else we say sorry, goodbye, tata. That's it. Don't overthink on additional judges now. What is this? Don't worry. Additional judges are appointed for maximum 2 years. If they perform very well, they are made permanent, or else they are said sorry, bye, ram ram. Clear? Now, we also have common high court for 2 or more states. Just like we have a common governor for 2 or more states. The exact same Amendment Act is there, 7th one. One more thing. Number of judges number of judges varies from one high court to another. So it is not that all the high courts have same judges. Okay. For example, the high court with the largest number of judges is the Allahabad High Court, 160 judges. Some high courts like Sikkim, how many? 3 judges. Bombay High Court, 94 judges. Madras High Court, 75 judges. Delhi High Court, 60 judges. Rajasthan High Court, 50 judges. Punjab and Haryana High Court, 85 judges. Look at Tripura High Court, 5 judges. Meghalaya High Court, 4 judges. Manipur High Court, 5 judges. It depends. The larger the state, bigger the area, more the cases, more the judges. Okay? So that is there. This is a list of all those high courts which cover more than one state or UT. Please tell me how many high courts cover more than one state? Number of high courts that cover more than one state. Tell me. Don't write 7, please. Don't write 7. Count. Please count. How many high courts cover more than one state? Okay. Wait, 15, 6, 7, 9, 2, 25. Let me help you. Bombay High Court. Bombay High Court covers state of Goa and state of Maharashtra. Guwahati High Court covers Arunachal, Assam, Mizoram, Nagaland. Punjab and Haryana High Court covers Punjab and Haryana. 3 high courts only. Other 4 high courts don't cover more than one state. They cover a state and a UT. Okay. So that was a question. And there is one high court which covers 2 UTs only, no state. That is the Jammu and Kashmir and Ladakh High Court. It was earlier called Jammu and Kashmir High Court, but recently the name was changed and now it is called the Jammu and Kashmir and Ladakh High Court. We have only 2 high courts which are meant for UTs only. One is Delhi High Court, the other is Jammu and Kashmir and Ladakh High Court. Clear? That's it. Solve this question, please. %61% got this correct. In India, every state has a high court in its territory. Of course not. In your territory, that may not be the case. So A is wrong. If A is wrong, A is not true. A is not true. A is not true, A is false, R is true. You will get a high court, but not inside the state's boundary. Look at Guwahati only, Guwahati High Court. So you will not have that the High Court is there in all the state's boundaries, inside the territory of the state. That will not be the case. But you will get one High Court allocated to you, where you can go and file cases. As simple as that. Andhra Pradesh and for example, Telangana. So they were functioning with originally in the same High Court, the Andhra Pradesh High Court. See, reason, the Constitution provides for a High Court in each state. Now, this can be a very vague kind of statement, but since A is wrong, no problem, right? So we could have mentioned a slightly better word here, but then the problem is that A is wrong, we have the answer. No need to nitpick on the statement. Now the appointment. Do we know the appointment procedure of High Court judges? Tell me. Please write the collegium. Write the collegium. What does the High Court collegium contain, or what does the Supreme Court collegium contain? CJI plus the two senior-most Supreme Court judges. So we know very well the appointment is done under Article 217 and it is done by collegium. Okay. This collegium has CJI plus two Supreme Court judges. For details, refer to the PPT taught yesterday. Okay. Now, every judge of High Court shall be appointed by the President, by a warrant under, not by Governor, please, by a warrant under hand and seal, after consultation with the Chief Justice of India, the Governor, and in the case of appointing a judge of the High Court, Chief Justice of High Court. And mind you, they shall hold office until they attain the age of how much? Not 65, 62. Supreme Court retirement 65. High Court retirement 62. Difference. Okay. This is the appointment. We have plenty of information on the appointment of the Supreme Court judges. This would be sufficient information. Nothing extra is required for the examination. Coming to qualification, we have similar kind of qualification, but here there is no. Okay. My question: the qualification for Supreme Court judge, you have to be a judge of High Court for 5 years or an advocate for 10 years. What is the third qualification? Tell me. Okay, distinguished and eminent jurist. Very good. Minimum 10 years. Or a judicial officer. Minimum 10 years. Who is a judicial officer? Judicial officer is somebody who is a judge in the lower court. That person is called a judicial officer. Are we clear on this? District judges, they are called judicial officers. Now, of course, please don't ask me, sir, should they be citizens? Of course, they have to be citizens. Okay. Then, one more thing. Please tell me. Removal. How are the judges removed? Same as Supreme Court judge, right? By the parliament, order of president, special majority, they are removed. Judges Inquiry Act. Oath and salary. Where is the oath mentioned? Where is the oath mentioned? Schedule 2 or 3? Oath is mentioned under Schedule 3. Salary is mentioned under Schedule 2. Okay? Please don't be confused. Now, we know very well salary is charge expenditure. Now, one more thing. They are debarred from practicing in all those high courts where they have acted as a judge. That is, after retirement. Did we understand this point? No? How innocent. See, let us take the example. Example here. There is one Justice ABC. This judge started his career as a judge in Patna High Court. Then he got transferred to, say, Sikkim High Court. Then he got transferred to MP High Court. Finally, he became the Chief Justice of Bombay High Court. And then he retires at the age of 62. Now, this judge, after retirement, can he practice in Patna High Court? No, he cannot. Can he practice in Sikkim High Court? No, he cannot. Can he practice in MP or Bombay High Court? No, he cannot. Debarred from practicing in all those high courts where they have acted as a judge. But can this Justice ABC practice in, say, Madras High Court? Yes or no? Yes, he can. Can he practice law as an advocate in Supreme Court? Yes, of course he can. Are we clear? So if you have retired as a High Court judge, then you are only not allowed to practice in those high courts where you have been a judge. Other high courts you can practice. Even Supreme Court you can practice. Are we clear on this? Okay. Smruti Kalyani, I had answered this question yesterday only. See, question has come. If you are eligible to, if graduates can apply for UPSC, can postgraduates apply for UPSC? Yes or no? If graduates can apply for SPSC, can postgraduates apply for SPSC? Of course. Similarly, if a High Court advocate is allowed to become a High Court judge, can a Supreme Court advocate be allowed to become a High Court judge? Yes, he can. Subject to 10 years of minimum service in any High Court or Supreme Court. Does not matter. Are we clear on this? This is all about our amazing High Courts, basic information. Please, I have mentioned this earlier, but I'll remind you, salary comes from the state, pension comes from center. Salary comes from state, pension comes from center. Okay, Nitesh, my doubt. What is your doubt, sir? It's okay. Some things will happen. Don't worry. These exact dates and things may not be required in the main examination. And in the prelims, you already have the options. Don't stress too much. It's too much of information. It's okay. Shalu, who administers the oath for Supreme Court and High Court judges? For Supreme Court, it's the President. For High Court, it's the Governor. Moving on. Sanskar, judicial officer means district judge. Who is district judge? We'll come to it. Any judge in the subordinate court. Judges in the subordinate court are called judicial officers. Lower court are called judicial officers. Now comes the jurisdiction, the power of the high courts. They also have original jurisdiction. For what? Electoral disputes. Any election dispute involving MP, MLA, MLC. MP, MLA, MLC. You can directly go to High Court and only High Court. You can't go to lower court. And Admiralty. Admiralty means involving law of seas. So think of this. India's map. Peninsular India. Let's assume. If a crime is committed here, then the case will be filed in the corresponding high court involving law of seas. So any matter which takes place in the seas, the territorial waters of India, it directly goes to the high court. Are you clear? So if you want to commit any kind of crime and you feel that my crime should be taking place or my case should only be in the high court, then go and commit a crime in the water. Not internal water, external water. Don't commit any crime. I am not promoting any commitment of crime just to go and visit High Court. Please. Are we clear on this? Then appellate jurisdiction. See, appeal, appellate, appeal. So basically, high courts are meant to be courts of appeal. Every case in the lower court goes to high court. It is mandatory. No permission is required. No permission is required whatsoever to appeal against a lower court's judgment in the high court. Nothing is needed. Clear? And then we also have something called writ jurisdiction, Article 226. This is just the writ or the order or the directives issued to protect the rights of people. Mayank, panchayat municipal election disputes, they are decided by the respective state legislatures. States make laws to decide how the election disputes will be decided. Okay? It is not the High Court or Supreme Court's concern. Solve this question, came in the year 2007. Old question, hopefully you'll mark the answer. Easy one as well. And I'll be back in 2 minutes, guys. Just give me 2 minutes. Okay, so a lot of you mark this correct. The mode of removal of a judge of High Court in India is same. Of course, it is same. After retirement from the office, a permanent judge of a High Court cannot plead or act in any court. This is wrong. They can plead or act in Supreme Court. They can plead or act in other high courts. 2 is wrong. A, 1 only. Thota, what is your question, bhai? If High Court judge retired, he himself disqualified by age, how he can practice in other courts? I didn't understand it. Practicing as a lawyer in other courts. Anyway, rephrase the question, Thota. I don't understand the question only. Now coming to the subordinate courts. When it comes to subordinate courts, lower courts, trial courts, how many judges do we have in the lower courts? The exact number is not needed, but I'll write it. 25129 judges. There is no need to know this figure. You can simply say over 25,000 judges. Are we clear on this? Don't be obsessed with figures, because there are hundreds of figures for you to remember. So rough estimate. Now don't write 10,000. That is too less. Over 25,000 is a sufficient number. That is okay. So subordinate courts. Now subordinate courts, the term, the nomenclature varies from place to place. There are at the district level inside a state, High Court at the top. In every district you have the topmost court called District and Sessions Court. This is the highest court of appeal in any district. Okay, topmost court. This is where you have the district and sessions judge who sits. Now, at the subordinate court level, we have two different sides. One is the civil side, the other is the criminal side. Civil. Criminal. Okay. At the criminal side, the judges are called sessions judge. And that court will be called sessions court. At the civil side, we call them district or civil judge. Below this person, additional district or civil judge. Below this person, additional sessions judge. All these people that you are seeing here, they are collectively known as higher judicial services. Okay. Now, at the civil side, below this person, we have a subordinate judge, also called sub-judge, sub-judge 1, sub-judge 2. In some states, they will be called subordinate judge senior division. In some states, they are called subordinate judge /1. Below him, you have subordinate judge, junior division. Then some states also have munsif courts. Munsif. All these are nomenclatures. It is of no concern to you. Don't worry. You're not doing a PhD here. Not required. At the criminal side, we have somebody called Chief Judicial Magistrate. Below him, we have Additional Judicial Magistrate. Below him, you have Judicial Magistrate First Class. Some states also have second class. These are the people who are authorized to issue arrest warrant. So next time when the police comes to arrest you, you ask them, show me the arrest warrant, and there should be the seal and sign of Judicial Magistrate First Class. Then only get arrested. Otherwise, run away from there. That is the lower judiciary. Now, worst straight line. This is a better straight line. Now, at the lowest level, we have somebody who is called a magisterial cum civil judge. See, when it comes to magistrate, the criminal side, magistrate cum civil judge. This person is the lowest ranked judicial officer in the country, and all these people collectively are called lower judicial services. Now, as far as the Indian Constitution is concerned, all these people till here they are collectively called district judge. Are we clear? There is a common name for all these people. Every such person, they are collectively called district judge, except the lowest one. Lowest one is not called district judge. Are we clear? This is where you go to magistrate, then go to judicial magistrate, etc., higher, and then go to the high court. Clear now? Now I hope you understand this word judicial officer, district judge. All these people, they are the judicial officers in the country. Okay? District judge is covered under Article 233. This person is covered under Article 234. Clear on this? One more piece of information. The sessions judge at the session side, they can also punish with death sentence. Maximum punishment, death sentence. So even the subordinate courts can give death sentence, but it is subject to confirmation by High Court, not appeal. Let us say the District and Sessions Court has given you death sentence and you don't want to appeal. You say, okay, judge, I will die. Even then, the punishment will only be executed if after High Court approves. Okay, done. And then you will be killed. So, but the point is that the sessions courts are allowed to give death sentences. Clear? Now, how are these people hired? Magistrate cum civil judge. So in every state, you have this very non-corrupt body called State Public Service Commission, a very fair and transparent body in every state. Remember, SPSC, State Public Service Commission. So that is there. SPSC conducts the examination for lower judiciary, the State Judicial Service Examination, right? SPSC conducts exam. Basically, the exam papers are also set by High Court only, and the interview is conducted by the High Court. This is how the magistrate cum civil judge is hired, through an examination. That's it. That's the only person in the entire judicial service who is hired through an examination. How are these people hired, district judges? There are two qualifications. Either by promotion, an officer in the judicial service of the union, that is via promotion. Very simple. If you are a additional JM, you are promoted, and people can cross any side. If today I am a sessions judge, tomorrow I can be a district judge also, no problem. Are you clear? Second qualification is you have to be an advocate for 7 years. Advocate or pleader is the same thing for 7 years. Pleader means somebody who pleads in the court. In our country, only advocates are allowed to plead in the court. Are we clear on this? This is with respect to our appointment of the lower judiciary. So that is sufficient information. Don't worry. That is all that we need to know as far as our structure of judiciary is concerned. Aryan, sir, if someone who is punished with life imprisonment or 10 plus years imprisonment, can he demand for a death sentence penalty? Because it is always better to die than life. You made me read this entire question for this. Yes, you can demand anything, but you won't get that. CJM, Chief Judicial Magistrate. Chief Judicial Magistrate. By exam, people become district judge. How? Huh? By exam, people become district judge. By promotions. Somebody who is a person holding this post, maybe some internal examination becomes gets promoted. This is the person who sits for a competitive examination. Are we clear? Magistrate cum civil judge. Yes, Rishabh, everybody, all these people are called district judges. Hierarchy, not important. Until and unless some case is filed against you and you are going to court, remember the hierarchy. If for examination, it is not important. Clear? And let's hope no case is filed against you. But don't worry. When you fill the UPSC form, they will ask you, is there any pending court case against you or not? That may not be an obstruction in selection, frankly. Now, what SPSC means? State Public Service Commission. So, if you don't know SPSC, you ask your friends or some senior people, they will tell you nice things about State Public Service Commission. Whichever state you belong to, does not matter. In our country, we are divided in one aspect. State public service commissions in every state are equally transparent, are equally fair, and are equally amazing in performance. No diversity here. Okay, so couple of hours back, we had mentioned this, that rich people getting to Supreme Court, hiring of lawyer, all this happens. What about poor people? How will poor people get justice? So for that, in fact, there is an article in the Indian Constitution, a DPSP, called Article 39 capital A. This article says that the state should strive to provide for free legal aid. Free legal aid for the poor. This is the effort that we should be taking. Are we taking the effort? Yes, we have actually passed a law. In 1987, Legal Services Authorities Act was passed, under which a body was created. That body is called NALSA, National Legal Services Authority. NALSA. Access to justice for all. That's the motto of NALSA. NALSA came into force in 1995. NALSA is governed, or NALSA is controlled by the Supreme Court. Okay, so there is a person called Patron in Chief, the boss of NALSA. Who is the boss of NALSA? Chief Justice of India is the boss of NALSA. But see, he does not perform the functions. He is just a ceremonial head, like a chancellor. The real executive chairperson who actually looks into the functioning of NALSA is the senior most Supreme Court judge. That is after CJI. Whoever is the next senior most Supreme Court judge, he looks into the actual functioning of NALSA because CJI is also busy. What's the purpose of NALSA? To establish a nationwide uniform network for providing free and competent legal service to weaker sections of the society. Free and competent legal service to weaker sections of the society on the basis of equal opportunity. Okay, so basically we have this entire concept of one NALSA at the head in the country. Under this NALSA, you will find there are some things called SLSA, State Legal Service Authorities. SALSA, not the dance form. Under every SALSA, we have at the district level DALSA, DLSA. And below that, at every taluk level, not TALSA, it is TLSC, Taluk Legal Service Committee. So at various levels, we have these bodies, this structure, which provides for competent, quality legal service, good quality legal service. Okay, this is what they provide. We have in our country, number not important, 37 salsas, 673 dalsas, and 2,281 TLSCs. Apart from it, we have 39 High Court Legal Service Committees, we have Supreme Court Legal Service Committees, various bodies are there, right? And just to mention this point, the center in 2021 allocated 145 crore rupees to all the salsas. Kerala got the highest amount, so center also gives the funds. What does the entire network do? Legal aid and assistance. Number one. To all eligible categories of people, legal aid and assistance is provided. Outreach programs are conducted, right? Then Lok Adalat and mediation. What is Lok Adalat? Please, I'll tell you later on. And victim compensation schemes, they are also provided. So basic key programs are there. This is what they do actually. They provide free legal aid, advice, counseling pertaining to all such matters. Just to point this out, in 2021, almost 63 to 64 lakh people benefited. They also spread legal awareness programs. Again, 2021, 11.34 lakh programs were conducted across the country to spread awareness about rules, regulations, court procedures in the country. Okay? Then, conducting Lok Adalats, ignore this, we'll discuss this later on. Promoting other ADR methods, alternate dispute resolution. We'll discuss this also with Lok Adalats tomorrow only. Preventive and strategic intervention programs, right? So we have various NALSA schemes, right? NALSA runs various schemes also. For example, there is this scheme called NALSA Legal Service to Disaster Victims Act of or scheme of 2010, or there's a scheme called NALSA Victims of Trafficking and Commercial Sexual Exploitation Scheme of 2015. Then there's a scheme called NALSA Legal Services to Workers in Unorganized Sector Scheme. Various schemes. Various schemes are run by NALSA. Then we also have same outreach program schemes, same thing. Then NALSA also takes part in what you can say is some kind of social litigation. For example, the transgender rights, very popular case of 2014 was on transgender rights. NALSA versus Union of India, or one 2012 case of all the widows in Vrindavan. That case was also fought by NALSA only, pressurizing the government into spending money for the betterment of lives of widows in Vrindavan. So these are all examples of various cases that NALSA takes up as an organization. So what does NALSA provide? Free legal services. What will be free legal service? Payment of court fees, any processing fees, any court fees that is required to file a case. See, filing case is not free. You have to pay some court fees. That fees, NALSA will pay for you. SALSA, DALSA, TLSC, they'll pay for you. Don't worry. Providing service of lawyers. Lawyers, they will also provide the service of lawyers. Let me remind you and let me tell you, NALSA has, and including DALSA, etc., roughly 50,000 lawyers are there in their panel. 50,000 plus lawyers. Okay, 50,168 is the exact number. Those many lawyers are there. Now, please don't compare these lawyers to Harish Salve or Kapil Sibal, etc. Let's be realistic also, right? Please. Then, if you want to get any court document, any court order, etc., then obtaining and supply of certified copies of orders, all these things, NALSA, SALSA, DALSA will help you out. Then, preparing for appeals, paper books, all such things, translation of any judgment, every such thing, whatever and wherever money is needed in the court system, they will help you out. Free, no money charged. But then the point is, free legal service for the weaker section, not for everybody. So for whom is this free legal service? These are the eligible people. Don't go to SALSA tomorrow only. Come on, I want to file a case. Women and children, free. Members of SC/ST, they can approach. Transgenders whose annual income does not exceed 2 lakh rupees, they can approach. Industrial workmen, they can approach. Victims of mass disasters, disabled people, persons in custody, people whose annual income is less than 1 lakhs. Look at this. When the government has to help poor people, then you are saying that who is a poor person? Whose annual income is less than 1 lakh rupees. But when you have to give reservation, then you are saying poor means annual income 8 lakh rupees. This disparity. I mean, if you feel that the economically weaker section person is somebody who earns 8 lakh rupees, then this should also be 8 lakh rupees only. This is, here there is no vote bank. Reservation, vote bank. So there they have increased the limit. Then victims of trafficking in human beings or begar. These are the people who are eligible. Are we clear on this? What creamy layer of, there is no creamy layer in SC/ST. Okay, you won't know for now, but there is no concept of economic criteria amongst scheduled castes and scheduled tribes. When we study reservation, I will tell you why and what's the reason for reservation for SC/ST. It is different for SC/ST and it is different for OBCs. Reservation criteria is different for these communities. Okay. So this is there, the eligibility criteria. That's it. This is NALSA. So please solve this question, a very simple, easy question, not at all difficult. Priyanka, if woman wants to complain and she earns more than, yes, free of cost, don't worry. Approach NALSA. Who is stopping you? I mean NALSA, SALSA, DLC, wherever. Okay, easy question. Nothing much to worry here. Person with annual income less than 1 lakh rupees is correct. So one is correct. This can't be the answer. This can't be the answer. Now either 2 or 4. What is 4? All senior citizens. Rajnikant is a senior citizen. Amitabh Bachchan is a senior citizen. In couple of years, even Salman Khan will become a senior citizen. They don't need any kind of help. This is wrong. Remove this. A, 1 and 2 only is correct. Transgenders with annual income of less than rupees 2 lakhs. Let me also tell you, this concept of transgenders is only in Delhi, not in other places. Are we clear? But I don't know why they gave this option such a vague option. And also, person with annual income of less than 1 lakh, it is not standard everywhere. Lot of states have increased this limit. In some states like say Bihar and Rajasthan, the limit is 1.5 lakh rupees. Bihar, Rajasthan, it is rupees 1.5 lakhs. Or in states like Andhra Pradesh, Himachal Pradesh, Assam, Haryana, Maharashtra, Tamil Nadu, the limit is 3 lakh rupees. But UPSC, it asked a very blanket kind of question, right? And people from Mizoram, you'll be surprised. Anyone from Mizoram, in Mizoram, the limit is 25,000 rupees only. In Mizoram, the limit is just 25,000. If you earn above 25,000, sorry, no free legal aid for you. That is all. So you can see very well how nicely the questions are made in UPSC. Clear? So this is there. That's all as far as NALSA is concerned. We are done with NALSA. Now, before we discuss the issues concerning judiciary, first we'll address judicial independence. Very simple, very logical. Why do you need judicial independence? Firstly, the need for judicial independence. If judiciary is not independent, the separation of power, checks and balances, L, E, J, how will we operationalize this? Don't ask me what is LEJ, please. It will be an emotional trauma for me. I will not be able to sleep the whole night. L stands for legislature, E for executive, J for judiciary. Okay. So, if you do not have strict separate organs of the state, how will we keep a check on this government? Who will control the government? That is why we need an independent judiciary. Number one. Number two, see, go to Supreme Court, go to High Court. In most of the cases, government is one party. Somebody has filed a case against the government only. That's the situation. Then rule of law. So you won't know what is rule of law. Let me tell you. Rule of law basically refers to government which is based on principles of law. What is this kind of rule of law? Rule is not of people. Rule is of law. Meaning, law is ruling the country. People don't govern. Whoever is holding a post, he is only implementing the laws. Meaning, what? Everybody is equal in the eyes of law. No biasness, no partiality. No arbitrary powers for the state. Limitation on whose power? State's power. Who can keep a check on the state's power? Judiciary, but only if it is independent. Otherwise, how will it keep a check? Then, also to protect the democratic rights of people. See, in a democracy, majority of the people vote and choose the parliament. What is parliament? Parliament is basically reflective of the majority. What is the government? Government is meant for majority who have voted and chosen you. So for the majority and their interests, we have the government. Who will protect the interests of minorities of various kinds? Linguistic minority, caste minority, religious minority, sexual minority. Who is going to protect you? Judiciary. So that the laws in the country don't become a play tool in the hands of government. There is no tyranny of majority. Just because the government has been voted by majority, they should not undermine the rights of minorities. So judiciary protects the minorities, and also to preserve the norms of federal polity in the country. Federalism. States' powers to be protected against central interference. What is federalism? Division of power between center and states. It is an independent judiciary which solves the federal disputes, state-center disputes. So this is all about judicial independence. Yashika, second point. In more than half of the cases, I don't know how to explain this further. In more than half of the cases, executive, meaning government, is one party. Somebody has filed a case against government, or government has filed a case against somebody. If government is a party in one case, and if judges are not independent of the government, then how will they ever give a fair judgment in your favor? Right? That is why independence from the government is required. What steps have we taken to ensure independence? All these steps. Some are even constitutional. For appointment, we know it's too much of independence now. The collegium system. For removal, it is actually a special majority. And the removal process is so difficult that we have not been able to remove a single judge of Supreme Court or High Court. One more thing, very important. This is Article 121. Mind you, the conduct of judges of the Supreme Court, High Courts, it cannot be discussed in the Parliament. In the Parliament, in the state assemblies, etc., you cannot discuss the conduct of any Supreme Court, High Court judge. That amounts to breach of parliamentary privilege. Okay? So a privilege motion can be moved against you if you discuss the conduct of a judge. Sorry, not allowed. Only when they are being removed, you can discuss. Otherwise, no. Then they are debarred from practice in future, especially in Supreme Court, Article 124, Clause 7. Then their salaries, their allowances, they are fixed. Government can only increase their salary, can't decrease their salary while they are in office. Then they have the power to make their own rules. Article 145. Supreme Court makes its own rules. And then contempt power. Meaning what? Supreme Court and High Courts are court of records. And if you make any kind of derogatory remark against the court, don't follow their order, then they can punish you with jail sentence also, which can be up to 6 months of jail. Are we clear on this? This is how we ensure independence. Fourth point. Sakshi, we have discussed this 4th point today only, na? That Supreme Court judges are not allowed to practice in any court in future once they have been a Supreme Court judge. Read this article, 124 Clause 7. It is mentioned in your slide under oath and what is that? Salaries. Okay? That's it. Let's take a break. We'll take a break after this question. This will be our last slide for the day. Please solve this question. Let's end on a winning note. 1 minute of time. Full enjoyment. Okay, a lot of you mark this correct. What is the provision to safeguard the autonomy? Safeguard the autonomy. While appointing the Supreme Court judges, the President of India has to consult Chief Justice. Of course, one is correct. One is correct. Remove this, remove this. So 3 has to be correct, no problem. Let's check 2. The Supreme Court judges can be removed by the Chief Justice of India only. Of course not. They can be removed only by the Parliament. 2 is wrong. This is wrong. You get the right answer with only 2 statements. This is how we solve questions through elimination. All appointments of officers and staff of Supreme Court of India are made by government. No, it is made by Supreme Court after consulting the President. It is the exact opposite. Supreme Court makes its own rules. That's it. Let's end our discussion here only. We'll begin our discussion tomorrow from this very important issue, and that issue is going to be pendency of cases. Why this much of delay? Why these many cases pending in the courts? Justice delayed is justice denied. That's all for me for today, guys. Jai Hind. And yes, leaderboard. Natrajan 120. Amardeep, Kanishk, Priya, and then we have other people. Okay. Done? Great. J.M. Barboza, that is also done on the collegium only. Collegium. Every recommendation for the appointment comes from collegium. Parveen, we'll discuss this towards the end of judiciary. So hopefully end judiciary discussion tomorrow. Once we end the entire discussion, we'll discuss activism, PILs, lot of things, tribunals. Then I'll discuss all the important articles. Sneha, contempt power. Sneha, contempt power basically means when you make any kind of negative remark, derogatory remark against the court, any statement that lowers the dignity of the court, that attacks the authority of the court, that scandalizes the court, or if you deliberately, knowingly, willfully disobey the court's order, that's called contempt of court. Kamal Pal, not always. That may not always be the case. It depends on circumstances. One slide back. Jyoti. Okay, ji, one slide back. Shalu, not really. Difficult to have an independent question on NALSA, but you can use this point in mentioning how we are providing for justice for all people or justice for poor. So that can be used in your answer, but an independent question on NALSA, not possible. If High Court judge retired, he himself disqualified by age, how can he practice in other High Court judge? Thota, practice as an advocate. How can he practice as a judge? You don't practice as a judge. You sit as a judge. Practicing as a lawyer, as an advocate. Practice means what? Legal practice. That is meant for lawyers. Judges don't practice. Yes, Devansh, center provides the funds. Swarufuddin, that is because Supreme Court has interpreted in this fashion. What to do? What can we say? Shalini, eligibility slide. Eligibility slide. Salam. Sir, I always give answer for those questions and got correct some of them also. But always have zero scoring. No. Leaderboard only shows top 20 scorers. So it does not show all of the people. So that's there. Once you score all questions correct, your name will be there in a leaderboard. I don't control leaderboard. I don't know anyone personally, frankly. Parveen, age limit of advocate? Advocate's age limit? There is no age limit. It depends on your skill. Ankita, sir, in Bihar, Nitish Kumar changed the law that if someone had to go death sentence, then in Bihar only 14 years. No. Not that, Ankita. What has happened is that the jail manual regulations have been modified, that earlier the remission period was 20 years. Now, for if you have been given jail sentence for killing a public servant on duty, then that has been excluded. So now normal remission says 14 years. But under certain crimes you had committed, the remission period was 20 years. That crime has been removed. Okay. A former district magistrate, I think he was a DM of Vaishali or some other district, I'm not sure, who was crossing that area and aggravated by one local leader. One local goon there killed him and people stoned him to death. Pranay, judges of Supreme Court are not debarred from practice. High courts are. Okay, Gopalganj, yes, Gopalganj DM. Saksham, we'll do this tomorrow. Money earned by advocates, why will it not be taxed? It will be taxed. We go from SJB to DB in High Court after judgment of SJB is given. Then transfer case to division bench. Shalu, I have already answered this question. I'm not sure what is your question exactly. Please rephrase your question again. Anand Padmanabhan, if the petitioner does not know the judge is the accused man's best friend, then judge appear for the case. Your loss, what can we say? My point is very simple. It is for you to prove, right? Judge will not know. Lawyers will not know. It is for you to prove it. So when a case is filed in the court, the lawyers have to prove it, right? So the onus to prove such things is on you, not the judge. Devansh, not mandatory. It's not possible also, not mandatory. Civil case is a case where the punishment is in some kind of compensation, monetary compensation, etc. Criminal case is a crime against society at large, where the punishment can be fine or a jail sentence. How can retired judges still practicing? Yes, pension they'll get, no problem. A district magistrate is an old used term. He will not give any kind of judgment and all. SJB to DB, you can appeal against a judgment of a single judge bench in the same High Court. That's it. It's a part of internal High Court appeal. It's not called appellate jurisdiction. What is to explain here? I have filed a case against one judge. I did not like the judgment. I went to the same court. I said, no, I want to file the case again, review to the next level. That's it. And what is it, Rohit? 2 slides back, 1 side back. Swarufuddin, I have no idea. And please rephrase your statement. It is not removing Article 370. It is modifying Article 370. Article 370 is still there. Statement is incorrect. District judges slide. Shruti, no, that does not happen. Come on, it is not possible. No punishment for overturned judgments and all. That is not possible. Rephrasing means don't say removing Article 370. Article 370 is still there. Article 370 has not been removed. It has only been modified. Okay. And as far as elections are concerned, I think the Home Minister has said that he'll be conducting elections by the end of this year. Let's see. Rishan Dondor, it is chargeable. Government providing services, they are charging money for it. What is the big problem there? No, Sakshi, they cannot. M. Narendra, Article 30. Article 30 is for the minority educational institutions. MEIs have a right to run their own, minorities have a right to run their own MEIs. Fundamental rights. Ignore it. Abhiraj, what is so special about PM? Yes, of course, punishment can be given. Shalu, it is the Supreme Court only. Jammu Kashmir is a UT. Ignore that for now. Judicial independence. See, when it comes to judiciary, right now, don't study. Independence in which chapter, I don't know. This topic, lot of things I teach are not mentioned in the books. It is just that I have collected these points so that you get information at one place only on independence. What more do you want to study here? It's all the points. M. Narendra, Article 35A. What is this? Asking questions which are not related to the topic. Article 35A was added to the Indian Constitution but not available to us. It was meant only for the people of Jammu and Kashmir, permanent residents of Jammu and Kashmir. Okay. Providing some special benefits. The state legislature could provide special benefits to people who were called permanent residents of Jammu and Kashmir. We'll discuss that later on when we study Article 370. Abhiraj, revision. Simple. Solve more questions. Read the PPT 5, 10, 20 times. Swarufuddin, what is this? How can the president overrule Supreme Court judgment? What kind of question is this? No. Judiciary, Supreme Court, the boss. Are you asking me about mercy petition? Mercy petition is not overruling the judgment. I have accepted my mistake. I am willingly accepting that, yes, I am wrong. President, please forgive me. I am not challenging the Supreme Court judgment. Clear? That can't be challenged. Vamsi, only important articles, nothing else. Smruti Kalyani. So if they would not have accepted, then maybe somebody would have filed a petition and Supreme Court would have given a judgment. Simple. I think PPTs will be sufficient. Thota, PIL tomorrow. We'll discuss PIL tomorrow. Don't worry. Is the Hindu sufficient for preparation? For what? Current affairs. Focus on monthly magazine and the editorials of Hindu. Yes, Prince, it is possible. M. Narendra, what are you asking? First you asked 35A, then 356. We'll discuss all this when the time comes. President's rule. What is the point right now? We'll discuss that. Don't worry. Okay. Monthly magazine. Any current affairs monthly magazine of any coaching institute. Byju's also would be okay. Read the Byju's. How option 1 is right. Abhishek, while appointing Supreme Court judge, does the president have to consult CJI? Yes or no? Tell me. Collegium system. What is the problem here? Okay. Yojana and Kurukshetra selective compilation reading is required. Okay. So that is all as far as today's discussion is concerned. Let's meet tomorrow, guys. Till then, that's all for me. Jai Hind.